Hi, this is Anthony Parent of Parent and Wynn LLP, the IRSMedic, and this webinar is FBAR help for those who are not in an FBAR amnesty program. What is going to happen now? And again, our assumption here is that you're not in an FBAR amnesty program, aka sort of offshore voluntary disclosure program or a streamlined procedure. There's a lot of people who aren't that the IRS is picking up on. And so this is for those people who are not in one. And so there's a few different scenarios that we see, and we're going to run through those right now, and I'll go in those more detail in a little bit. The first is if the IRS or Department of Justice has not contacted you and you're not in an OVDP. The second is if you're under examination, which is the IRS word for audits. 3 is that the IRS has made an FBAR penalty assessment against you already. 4 is if you've lost your FBAR appeal. 5 is, let's say that you lost your appeal and now the IRS is suing you, or actually technically the US government would be suing you. 6 is that this is where things get serious. 6 is the government is now investigating you criminally. And 7 is when a grand jury has turned an indictment against you for failing to file an FBAR. So let's talk about the first case. Let's say that the IRS or Department of Justice has not contacted you. What should you do? Well, there's still time to act. I would advise you to watch our materials on the OVDP program and the most common OVDP FBAR questions. It might not be as bad as you assume. Or you can continue to watch this, especially this might give you the incentive to enter into a program. As I talked to one of the earliest FBAR defendants, John McBride, he told me getting into one of the OVDP, and this is somebody who's gone through the whole process, is a no-brainer. Now, let's just say that you are under civil examination or audit, and you have not disclosed anything to the IRS. Believe it or not, we've gotten cases where we've been able to get people into an OVDP who are in audit. It is actually possible to happen under some circumstances, so don't rule that out. Otherwise, you're going to want to treat your audit like a voluntary disclosure. Do the examiners work for them? They are likely interested in just one foreign account if that's what clued them on to audit you. You might have more than one. You also might have different types of accounts like foreign life insurance. Also, they might not know how to do the proper accounting, so you're going to be the one who wants to do that work for them. Basically, you want them to open this case and close it as soon as possible. Also, get your reasonable cause facts out there as soon as you can. The third type of case is, let's say you're under civil examination or audit, and you've made a soft or quiet disclosure. My first concern here is a criminal exposure. I've been told that the IRS is looking to bring indictments against those who have done a soft disclosure, or for those professionals who advise their clients to do a soft disclosure. And that's one of the big aspects about this is, who was your advisor who told you to do this? Because they're likely going to testify against you, so you might want to get what they told you out into the auditor as part of that record. Now, if your case can be pulled out of the fire, where there's not going to be, not going to be elevated to investigation or referral to criminal investigation, we're going to treat your audit again like a voluntary disclosure. Do the examiners work for them? They are likely just, again, interested in one foreign account, likely have more than one. Also, make sure your domestic income is 100% solid. That's why it gives them the best basis that they'll open this case, close it out as soon as they can, without this case sort of rubbing anyone the wrong way and somebody wanting to do more work than is absolutely necessary. Now, here's the thing. This is the truth. They really may be interested in going to civil trial. That is assessing that FBAR penalty and then suing you to make that to convert that judgment into something they actually can do to start levying it. Unlike a tax assessment, an FBAR they have to sue on it first. Tax assessment, they could just send out letters and start levying you. With FBAR, they actually have to sue you in order for anything more than intercepting your refunds to occur. Now, let's just say the IRS has made an FBAR penalty assessment. You've gone through an audit and there's an FBAR penalty assessment. Or even if you went through an OVDP opt-out, you'd have the same FBAR assessment. Now, in an OVDP opt-out, you're in a much better position because the IRS has no leverage to file criminal charges. Not so when you've made a soft disclosure or just going through the regular civil audit with no OVTP protection. There's two types of FBAR assessments. There's a pre-assessment and post-assessment. Either one gives rise to appeal. And that's what we would be doing in this case if the IRS has made such an FBAR penalty assessment. One of the first things we would do is request a Freedom of Information Act file on you to see what happened. Why did they assess the FBAR penalties? You see, the FBAR penalties procedures are so new to the IRS, and these guys are overworked to begin with. So the chances of them doing everything exactly right aren't 100%. And so if you can win on a technicality, that's a win. So FBAR appeals are new as well. And so there's a lot of things going on. So the important thing is that you fight, you don't roll over, and you fight on the facts, and you make sure you presented your best story. Now, let's just say that you went to an FBAR penalty appeal, and it was upheld. And that is your FBAR penalty assessment is final. What should you do? Well, as I said before, the IRS can be hell-bent on assessing FBAR penalties, especially if you made a soft disclosure. The key is not to roll over and to fight every detail. The IRS can start intercepting refunds at this point, and there's no CSED on FBAR penalties. The CSED is what we use with the tax assessments. It means collection statute expiration date. The IRS has 10 years from the date of assessment to collect on back taxes. For FBAR penalties, there's no such limitation, but what they do have to do is file a suit in civil court. They have 2 years to file a suit in federal district court to perfect that. So what you do want to get is that 2 years before they file a federal suit. If they don't, they're stuck with getting your FBAR penalties through refunds. And so that can be a win as well. It all depends on what their caseload is, and it depends on how much of a sore thumb you're sticking out. Did you rub somebody the wrong way, or is this one where they're going to give your case a low priority to prosecute because, well, they like you? That's what we kind of want. Now, let's just say that, well, the IRS did, or the Department of Justice, no, I'm sorry, the Attorney General of the United States, that is the person who actually would be suing you. Let's say that they did assess you the FBAR penalty, and now they are suing you. What should you do? Well, in this case, you need a litigation attorney. And I mean an actual litigation attorney. Just to give you a hint, we are not litigation attorneys. We don't claim to be. We are litigation support. We do everything at the administrative level. There's people who specialize in certain things. We work with trial attorneys to give them the support and detail that they need. We do a lot of the legwork for them. Being in a trial, I used to do it, and it is just a totally different game. And you're constantly beaten down by a process that is stacked against you. And so what you need to do is you need to give your attorneys the support, your trial attorney the support, so he feels that, or he or she feels that they can give it all. And then they also need some help from outside, so that we could give them the support and everything, and we could go over and say where the IRS is wrong. We could just look at their cases and say, no, this is where they're wrong right here. They're totally wrong. They have the wrong facts. They have the wrong law. That helps them out, and that's what we love doing. It's much better to have an administrative record, okay? And that's what we're doing. That's what we're talking about up to this point 5. You need to have that administrative record that supports your position, rather than trying to create one when you are sued. See, the IRS, the Department of Justice, Attorney General, they love slam dunk cases. That's what no one wants to have a loss. If you work for the government, getting a loss is horrible. So they want to have cases that they can't possibly lose. Now, to win or create some negotiating room, usually you just need to make the case not a slam dunk, and that can create a huge victory for you. Now, let's just say that you weren't audited and there's no FBAR penalty against you, but this is rather a significant, this is one of the worst things that could be happening, is that the U.S. Department of Justice is investigating you for unfiled FBARs. Well, here's the thing, and we've done this before. There's lots of people in non-compliance. Lots of people have made soft disclosures. Tens of thousands of people. The IRS, the Department of Justice, has to pick from to prosecute. What we're trying to do when someone hires us is we are attempting this Jedi mind trick to say, these are not the taxpayers you are looking for. And really, we're trying to give them a reason to go after someone who's not you. That's really our job. There is such a huge abundance of people in noncompliance. And for a lot of these FBARs, the Department of Justice has to weigh, they have to risk how much resources How assured are they going to get of a conviction because they want that press release? They really think it's somebody where a case there's a reasonable cause or it's uncertain. There's a lot of other people they can get to, and that's what we want to happen. Now, the worst case here is if you have unfiled FBARs and now you have a grand jury has returned an indictment against you for tax evasion or willful failure to file an FBAR. In this case, this is what you need. You need a great criminal defense attorney. Be sure that they are actual litigators. Ask them their acquittal rate. Do not be fooled by their websites. Ask them their acquittal rate. There are people who pose as experts litigators. They absolutely pose as expert litigators, and they have never litigated one criminal case in their entire life. They're not going to tell you that, but they will take your money. They will spend hundreds of thousands of dollars to negotiate a plea agreement that's rather unpalatable. And after you're presented with that plea deal that is rather unpalatable, you'll say, well, let's go to trial. And they'll tell you, oh, you need to get a trial attorney. Now you'll be spending a lot more. So isn't it better to hire a real criminal defense attorney to begin with? Again, that's not me, but I can tell you who the best ones are around the country, ones who actually get acquittals. Because the IRS, Department of Justice, knows that they're against a real attorney. Don't you think that there's going to be a better deal presented that may avoid trial to begin with? Or maybe they just drop the indictment. That does happen. Why? Because there's some attorneys better than others. And so that is absolutely critical. Just ask their acquittal rate. Don't let them skirt around that issue. They should know it. And by the way, if it's low, if it's not the highest acquittal rate, I do have a friend who has it about 80%, which is insanely high. Not everybody has that high, but even a few acquittals, that means you're a real litigator, and you might want to give them your attention. Now, here's the thing, all this FBAR litigation, it's all subject to change. It's exciting work, this FBAR, because it's all somewhat brand new, even though the FBAR filing obligations have been around since the Bank Secrecy Act of 1970. It's only recently that litigation has occurred, and the cases are very sparse. And so you're trying to apply fact patterns that might not apply in your case. So new laws being created all the time. And it's exciting work for attorneys, probably stomach-turning work for clients. And also there's that FBAR FACA litigation going on. And the same attorney who won the Citizens United case is representing the plaintiffs in that case. So that actually might have a chance of upsetting the apple cart. And there's also other FBAR litigation going on, prosecuted by other fine attorneys. So who knows? And the other thing, too, is that there's a thing called jury nullification. The public isn't exactly thrilled with the U.S. government right now, and the U.S. government makes jury nullification appear as it's illegal. And there's many commentators out there, like Glenn Reynolds of Instapundit, who's really putting out the word that jury nullification exists. And so a lot of juries, if you tell the jury that you're going to imprison this person for 5 years because they didn't pay all their taxes and they didn't file this form called FBAR that you don't know about, how would a juror feel about that? Do you think a juror would convict someone and want to take them away from their family, somebody who doesn't really appear much like a criminal, looks just like them, who made a mistake on their taxes that may have been negligent or may have even been intentional? The law separates juries from their consequences. But, this could all change as the word gets out what this law is, and that 50% penalties exist 6 times. Failing to file a form can put you in jail. A form that's supposed to get drug traffickers, terrorists, is putting regular people behind bars. Well, I think when juries hear that, things might turn different, but again, who knows what's going to happen? It's all subject to change. And because of that, we want to thank you for watching, and we want you to subscribe to our channel so you can keep up to date with a lot of the changes as they go along. Look for updates. If you have concerns, comments, info@IRSMedic.com, or call our FBAR hotline at 888-477-4258. This is Anthony Parent of Parent and Wynn LLP. FBAR help for those not in an FBAR amnesty program. Thank you for watching.